Excellent. So we're live on Facebook, Instagram, TikTok, across all social media platforms. You're all very welcome to this live session. Today we have a lot of exciting things to discuss. We're going to be discussing third country removals, which we had prepared for discussion. And then now we have some breaking news about the birthright citizenship issue. We'll be reviewing the written decision in detail. It's about 119 pages from the Supreme Court. So for now, we'll just talk a little bit about, from perusing and from those who heard the decision, what is happening, and then we can determine what to do and how it impacts us. Okay, so guys, join in. If you guys can see me and hear me very well, please type in USA in the chat box, or use the emoji of the United States, the flag, and then I can confirm that everyone can hear me and see me fine. Okay. All right, so let's get started with our discussion of the day. We have the third country removals case we'll be looking at, and we'll look at the birthright citizenship case also. So please stick with us, and so that we can take care of everything we need to take care of today. Okay. All right. So there have been a lot of back-to-back breaking news. I believe on, was it Monday? Well, 23rd of June, the Supreme Court issued a ruling concerning third country nationals, third country deportations or third country removals to third countries. All of those things are interchangeable. So that's what we're going to be looking at. Let me pull up my screen. Well, it looks like I'm okay. All right. Okay. So you guys, you already understand that so many crazy things are happening in the United States, and it's important that we, keep track, stay informed, so that we know how these decisions impact us and our loved ones and our stay in the United States. All right. So you guys know that when you're in the United States unlawfully, you can be ordered deported by an immigration judge. Here's one of the things that I tell people. Some people will get a letter from USCIS saying that leave the country in 33 days. And they say that, oh, they've been deported. But USCIS cannot deport you from the United States, okay? Generally, if you are in the United States, even if you're here unlawfully, you will have the right to see an immigration judge. Obviously, there are exceptions. There are other processes that will allow, low-level officers who are not judges to summarily remove you from the United States, like a process called expedited removal, or where you've already been ordered removed, they can reinstate the removal. So those are the things where you don't get another chance to appear before an immigration judge. But generally, if you're here and expedited removal doesn't apply to you, and other, fast track deportations do not apply to you, then everybody gets to see an immigration judge and then to have their day in court. Okay. After you are ordered deported, deportation may not always happen. There are many people who are here in the US and they are under an order of supervision. That's why they go for ICE check-ins. They've been ordered deported, but sometimes based on humanitarian reasons, or they don't have travel documents to go home, or they're just logistical barriers, barriers that prevent the government from removing them from the United States. And so when that happens, they continue to remain here, they would have work permits, and then they continue to live their lives here. Other people also, sometimes would file an appeal. They can be ordered removed by a judge, but they'll file an appeal. They are waiting for the appeal. And sometimes after the appeal comes, their case is denied. It just doesn't prioritize them to remove them. So there are many, many people, millions of people in the United States with final removal orders. I believe data says that there's about 1.4 million people in the United States with final removal orders who have not been ordered deported. Again, ICE has limited resources. They're not able to go after everybody and deport everybody. So those people are still in the United States. Now, if you are in court, there are some reliefs that you can accept, right? You can ask the judge for some relief, and you can ask for an asylum if you are being persecuted in your home country based on belonging to a particular social group, a religion, a race, or some type of political activism. Then, and you're being persecuted by either your government or an actor that the government is unable to control, then you can come into the United States. The US laws allow you to seek asylum for your safety. You can apply for Convention Against Torture. You can apply for withholding of removal, cancellation of removal, adjustment of status. There's these type of cases you can apply for when you are in immigration court. When it comes to things like Convention Against Torture and withholding of removal, the courts have clarified that you can receive protection called withholding of removal, but it means you are ordered deported. The only difference is that you cannot be deported to the country where you are afraid of being persecuted or tortured. So you can be deported to any other country in the world apart from that country. So we have a lot of these people here. They have been ordered deported, but they were granted withholding of removal. They were granted Convention Against Torture, or they are just here because there's no, their home countries refuse to provide travel documents to them, and they are here. Okay, now let me share this with you. In February 2025, the Trump administration gave a directive. You can see on my screen, this directive was issued to ICE officers in February 2025. Now, what the directive did was that it told ICE officers this. It says aliens granted withholding of removal or cat protection. Aliens are non-citizens. Withholding of removal under the Immigration and Nationality Act and under the regulations implementing U.S. obligations under the Convention Against Torture and CAT deferral of removal, DCAT, they are country-specific protections from removal. So being granted DCAT and CAT and withholding of removal, they are country-specific protections from removal. It means you have been ordered deported, but you just should not be removed to that particular country where you fear being tortured. Accordingly, the ICE directive continues. Accordingly, when an alien granted such protection reports on the non-detained docket, ERO officers should review the case to determine viability of removal to a third country and accordingly whether the alien should be re-detained. So now they're looking at two things. For the people who have been granted these country-specific protections, number one, you're going to be checking in with ICE. For some of them, they do ICE check-ins. Not all of them do ICE check-ins, but some do ICE check-ins. So for those who are doing ICE check-ins, ERO, which is the enforcement removal operations. It's an arm of ICE. The officers are the ones responsible for deportations, carrying out deportations. They have to review these cases of all these people who are in the United States and see whether they can be removed to third countries, and whether they should be placed back in ICE detention. Whether they should be placed back in ICE detention. All right, so now let's go back here. And so that was the basis upon which all these actions started. And, there were about, I believe, 4 plaintiffs that brought the suit to the court. Let me pull this up. 4 plaintiffs, about 4 of them that brought the suit and said they were going to be deported to third countries, and they had not been provided with an opportunity to contest their removals. They wanted written notice so that they could conduct some research about the countries they were being sent to. They could be allowed to raise fear-based claims concerning the countries where they were being sent to. There were a number of the plaintiffs. The first one, OCG from Guatemala, we talked about this on our social medias. He was granted an application for withholding of removal, and the only country that was designated in the withholding of removal was Guatemala. And DHS was trying to deport him to Mexico without any advance notice. But he had actually been to Mexico, where he was raped and kidnapped, and there was a ransom placed on him, and I believe his sister paid the ransom. And then he ran away from Mexico to the United States. So he was not told about his deportation until when he was on a bus with 20 other people who were going to be deported. And I told them, we're on our way to Mexico, you're going to be deported. And he's like, what? I mean, he said he was raped in Mexico, and he had tried to come here to seek protection. And now you are taking him back. If you had given this man written notice, then he could have raised his fear based on what had happened to him in Mexico. When he got to Mexico, Mexico also then deported him to Guatemala. And now he's apparently in hiding in Guatemala, according to the Supreme Court decision that was written by Sotomayor. Okay. Okay, so now Massachusetts has the final removal. I'm sorry. So the second plaintiff is DVD. He's called DVD, not his full name. He's from Cuba. He also, from Massachusetts, has a final removal order from 2017, following removal proceedings in which Cuba was the only country where he was designated, and he faces imminent risk of redetention. He also had to be doing ICE check-ins. The other, so that gave them the opportunity to try to deport him. Then MM is another plaintiff from Honduras. He also had withholding of removal to Honduras, which was the only country was designated for removal. And she was also doing ICE check-ins with ICE in Dallas, Texas. And 3 weeks after her last ICE check-in with that office, ICE informed her that she was on a list of people to be deported. I mean, these days, being on a list to be deported is very alarming news, because if your country is called it's labeled as a recalcitrant country, then unfortunately you may be sent to a third country, or a country which has entered into some type of agreement, bilateral agreement with the US to accept you, even though you may not be from that country. Okay. Now I'm going to share the Supreme Court case that we have, and then we can talk about it We look at what we have available and then see what the basis of the entire case was and what's going on now. All right, let's see here. So this decision was given by, I believe, Justice Barrett. Okay. And it was given today, 119 pages. So we're just going to look at the, the first page, and then we can go back to what the background of the case is. When Trump came into power on January 20th, 2025, he issued an executive order attempting to end automatic birthright citizenship. As many of you may already know, birthright citizenship is guaranteed under the 14th Amendment, and it's based on the principle of jus soli. Anybody who's born on US soil, they automatically obtain US citizenship. Obviously, there's an exception. People who are not subject to the jurisdiction of the United States, like diplomats, they will not obtain US citizenship, but all other persons, even if the mother was undocumented or the father of the baby that was just born in the United States, both of them are undocumented, the children obtain US citizenship. Okay. Now, the executive order, which was called, let me pull that up here, Protecting the Meaning and Value of American Citizenship, is sought to narrow the interpretation of subject to the jurisdiction thereof, and is sought to say that not everybody who's born in US soil is entitled to obtain automatic US citizenship. So 14th Amendment, the executive order is saying it excludes from birthright citizenship people who were born but who are not subject to the jurisdiction of the United States. And so what the executive order did was that it said that when a mother was in the United States and she was unlawfully present, and the father was not a US citizen or a lawful permanent resident, or when the mother is in the United States temporarily and the father is not a US citizen or a lawful permanent resident at the time of the child's birth, then the child will not obtain US citizenship, even though the baby is born on US soil. So in order for you to obtain US citizenship as a baby born on US soil, number one, your mother had to be here. One of your parents had to be a US citizen or a lawful permanent resident. If mom is here unlawfully or is here temporarily and dad is not a green card holder or lawful permanent resident, then you cannot obtain US citizenship. The executive order said that the policy to limit automatic birthright citizenship 30 days from the date of the order. So from January 20th, 30 days, when the date should have been in February. However, there were, there were plaintiffs, some states and some plaintiffs, some pregnant women who brought their action in court challenging this and said they were going to be impacted, they were going to be injured by this policy, and so the court should put a block on this policy that was supposed to take effect. There were several states that sued, and they sued in several district courts around the United States, in over 10 district courts around the United States. And some of the district courts issued nationwide injunctions, meaning if you brought the suit in Maryland and the judge granted the block or the injunction, the block took effect nationwide. Trump was not happy with this. He was very mad that district courts, how can you a president says something and a district court judge blocks it nationwide, and the Trump administration disagreed with this, what was happening. And so they filed this to the Supreme Court, arguing that the district court's judgments should not, or injunctions that they are issuing should not have universal effect or universal application, and that the federal courts do not have authority under the Judiciary Act of 1789, and they should only block enforcement as to the plaintiffs that have brought the case in court or to court. Obviously, the Supreme Court was not deciding on the merits of the policy or the executive order to end birthright citizenship, but they were just deciding procedurally, should injunctions have nationwide effect. The Supreme Court agreed with Trump, Justice Barrett, who granted the partial stay. So Justice Barrett, she was representing the majority. The Supreme Court ruled 6-3, again, not on the substantive issue of birthright citizenship, but on the procedural issue of whether injunctions should have nationwide effect. They disagree with that. And so they are saying block enforcement in only the states where these are brought, and only the individual plaintiffs who bring these suits. Okay. So the injunction, nationwide injunction, now remains in effect for only those states and those plaintiffs who were named in the suit. All right, let's see here. Here's what the Supreme Court, the initial note said. Plaintiffs, individuals, organizations, and states, they filed 3 separate suits to enjoin or to stop the implementation of and enforcement of President Trump's Executive Order 141/60, protecting the meaning and value of American citizenship. Now, the executive order identifies circumstances in which a person born in the US is not subject to the jurisdiction thereof. Okay, and as part of that, we've already discussed it. When mom is in the United States temporarily, or mom is here unlawfully, then according to the Trump administration, these people being unlawful in the US and being here temporarily, they are not subject to the jurisdiction of the United States. So they sought to identify where or circumstances in which a person born in the United States is not subject to the jurisdiction thereof and is not recognized as an American citizen. The plaintiffs were saying that, I'm sorry, I lost my line. The plaintiffs alleged that this was violating the 14th Amendment. And in the case, the district court entered an universal injunction, an injunction barring executive officials from applying the executive order to anyone, not just the plaintiffs. In each case, the Court of Appeals also denied the government's request to stay the sweeping relief. So after the district court had issued a nationwide injunction, the Trump administration appealed to the Court of Appeals and said, can you stay the relief or stop it? Can you unblock what's going on? The Court of Appeals denied it. The government argues that the district courts lack equitable authority to impose universal relief, and therefore they filed 3 nearly identical emergency applications. Wow, the Trump administration was not joking. They were so serious about this issue. They filed 3, not just 1. 3 nearly identical emergency applications seeking partial stays to limit the preliminary injunctions to the plaintiffs in the case. So they wanted the preliminary injunction to be limited to the plaintiffs in each case, not to everybody else. If you haven't bothered to bring a suit, then the argument was that then you should not get the benefit of the injunction or the pause or the block. The applications did not raise the question whether the executive order violates the citizenship clause in the U.S. Constitution or Nationality Act. Instead, the issue the court decides is, whether judges, federal courts have equitable authority to issue universal injunctions, right? So again, it's not a substantive ruling that the Supreme Court gave. It's just a procedural ruling. Let's go to page 2. All right. So this was what was held. The universal injunctions likely exceed the equitable authority that Congress has given to federal courts. And so, with that being said, federal courts no longer should grant such universal injunctions. This is likely to impact many cases moving forward. And, we're all wondering how the Trump administration is going to utilize this new power, because for several years, when a district court grants an injunction, sometimes, they do the nationwide, it doesn't take effect anywhere, a judge has blocked it, but now they are going to be really narrowed down. The issue raised by these applications, whether Congress has granted federal courts authority to universally enjoin or stop the enforcement of an executive order, plainly warrants this court's review. On multiple occasions and across administrations, the Solicitor General has asked the courts to consider the propriety of this expansive remedy, because this injunction remedy was very expansive, happening throughout the U.S. You grant, they block something and then it applies nationwide. As the number of universal injunctions has increased over the years, so too has the importance of the issue. Let me go here. Let's see. I'm not sure why my screen is. Let me see here. Hold on. Let's come. Okay. Now it says, Justice Barrett, who gave the decision, it said that the government is likely to succeed on the merits of its claim that the district courts lacked authority to issue universal injunctions. The applicant must make a strong showing of likelihood of success. The issuance of a universal injunction can be justified only as an exercise of equitable authority, yet Congress has granted federal courts no such power. Okay, there you go. All right, let's come here. Now, if you look on page 32 of the executive order, which is the opinion of the court, maybe we should just jump to page 32. Let me see if this is gonna work. Let's go to page 32. Okay, yeah, let's share the screen on page 32, please. When you go there, it tells you that the injunctions are also stayed to the extent that they prohibit executive agencies from developing and issuing public guidance about the executive's plan to implement the executive order. consistent with the Solicitor General's representation of the executive order. Oh, no, with the Solicitor General representation, Section 2 of the executive order, which I read to you. Section 2 of the executive order talks about the fact that the executive order should take effect within 30 days of the signing of the executive order, 30 days after January 20th, 2025. Now, Justice Barrett is saying that the executive order can take effect now. The executive order that purports to end birthright citizenship. She's saying that it shall not take effect until 30 days after the date of this opinion. 30 days after the date of this opinion. That's when it is going to take effect. All right, so we're going to go more into detail, and discuss this case in subsequent videos. We just wanted to touch a bit on this since we were already live and the news literally just broke. Usually when there's a ruling like this, there's a lot more questions that we have than answers, okay? There's a lot more questions because it's 119 pages. It will take time for anybody to review and actually digest and come out with more reasons, because it didn't take the justices just one day to write this. They've been drafting their arguments for several days now, doing their research, reviews, analysis, and they came out with a judgment. So it's going to take an equal number of time, if not equal, a similar amount of time to be able to review and digest what's happening. When the ruling has certainly raised a lot of questions, and it's fine that we don't have all the answers yet. Very normal at this stage. When the Supreme Court or any court rules on an issue, it cannot cover everything and everything under that. And even if it does cover, sometimes some of the things may be ambiguous or not be very clear, and it will take interpretation, implementation to understand what the justices meant in particular instances. Sometimes it will leave some details unresolved, open to interpretations, and so clarifications happen as time goes on. For example, a lower court, can apply, like a district court or appellate court, they can apply the Supreme Court's ruling to a real life case. Then those rulings, their decision in those rulings will help define what the decision meant in specific situations. Agencies could also issue guidance, federal agencies. In this case, Department of State, they are the ones that issue US passports to US citizens. When a baby is born in the United States, they get a birth certificate from the hospital, and then they can apply for US citizenship based on the principle of jus soli, born on US soil. Then Department of State will issue a passport for the child. Now, as it stands, Department of State is going to have, some work to do. They are going to have to issue guidance on what this means, how they are going to be moving forward with executing the Supreme Court ruling. How is this going to be interpreted? There are several questions that arise from this. Some of the states, there were some states that actually filed the lawsuit to challenge the Trump administration's end of automatic birthright citizenship, and they were granted injunctions. Washington State, Maryland State or State of Maryland, New Hampshire, Massachusetts, New Jersey. One of the questions, some of the questions people are asking is, what does this even mean? Well, if you are a mother and you are unlawfully present in the United States, and the father of the baby is also unlawfully present. What does unlawfully present in the United States mean? You came in without a visa. You came in with a visa, but your visa has expired. And number two, you came in temporarily. you are on a student visa, you're on a work visa like H-1B, you're here temporarily. Father of the child is also undocumented or is also here. If you are in the United States, I'm sorry, per the Supreme Court's ruling, in 30 days, once your baby is born, your baby will not obtain automatic citizenship. However, if you are in one of these states or the baby is born in one of these states, then the injunction that was put in place by district court to block the applicability or the executive order from going into effect will protect you. Now questions are arising. Okay, so if one person is a pregnant woman and she's unlawfully present in the United States, let's say she lives in the state of Washington, but Washington is one of the states where the injunction is in place against the executive order, meaning if a baby is born in Washington state and the baby's parents are not, U.S. citizens or green card holders, neither of the baby's parents is a U.S. citizen or green card holder, baby can still get U.S. citizenship just because the baby was born in the United States. If they were born in Washington, Maryland, New Hampshire, Massachusetts, New Jersey. Now the question is, what if the mother is a resident in a state where the birthright citizenship rule will not take effect? And let's say Washington mom now goes to the state of Virginia to deliver. In the state of Virginia, there's no injunction in place to block the birthright citizenship. Will the baby being born in Virginia impact the baby's citizenship status? These things are going to be clarified with more in-depth discussions and actual implementation in court, okay? The new legal challenges are likely. There's likely going to be more legal challenges. Obviously, the Supreme Court has said, well, if you want the ruling to apply to you, then you should bring your suit, or your state should bring a suit. Then if there's an injunction, it will apply specifically to your suit. Guys, make sure you're following this page, AK Poku Law. Give us a thumbs up. If you guys can hear me and see me good, I'm not getting any feedback. Please drop the US flag. Let me make sure all is well. I'm not just talking into myself. Okay, guys, so these are the questions that we're going to have answered, and it's likely that there's going to be a lot more legal challenges around the United States. I mean, the justices just increased, work for district courts around the United States and for attorneys, because now there has to be a lot more legal challenges. You want a relief, then you need one savior from your state who will bring the suit in your state, so that there'll be an injunction in the state of Virginia. You need one person in the state of Ohio or in the state of Texas or Florida who will bring the suit to block the executive order from taking effect. And you see, you guys, there's 30 days until this can take effect, according to Justice Barrett. And so, there's going to be a lot of legal action. There's likely going to be a lot of confusion. And oh my God, what a time to be alive in the United States. This is incredible. I mean, since January, there's just been back-to-back legal confusion in the system. It's really very, very interesting time to be alive. We just have a few more minutes for questions, but let me go back to, I had a couple of other things to discuss with you before this Supreme Court ruling, but again, we'll be reviewing the decision in more detail, and we'll be discussing some more. So please, if you haven't yet followed AK Poku Law, make sure you're following our pages across social media. Now, there is also another ruling, another issue. Let me see if I can go on and share my screen with you. Let's see. So in June 2025, on June 11th, it was specifically June 11, 2025, the Department of Justice, well, the Trump administration told the Department of Justice to start focusing or giving priorities to some cases for civil enforcement. Let me see if I can pull it up on my screen. Let's see. Okay, I'm going to hold on, guys. I'm going to pull it up. I want to be able to show you what's going on with the Department of Justice. There's a memo that was released on June 11th, 2025. And I've marked it out. So let me share the screen with you right here. There are 5 priority areas that the Trump administration and Pamela Bondi have requested Department of Justice to prioritize and focus on. Oh, okay. No, it looks like I cannot share my screen. Well, you know what? Let me see if I can do this here.